Colleagues, fellow journalists, media practitioners, friends of the media, even frenemies of the media. You know, they are friends of the media when everything is going well, and enemies of the media when they think the media is not covering well. But otherwise, we thank you very much. We are here to brief you on the progress that we have made thus far as the Media Alliance of Zimbabwe, which is a network of 9 media support and professional organizations, among them the union, Kuvashandi, Bushanda, the Editors Forum, the Media Institute of Southern Africa, the Press Council, those that represent community media, community radios, community publishers. We also have under the umbrella Gender and Media Connect. All colleagues are just united by one objective: to free the airwaves, to free the media. And we are here to give an update on what it is we've done collectively. And we're actually happy that 2 of our partners, MISA Zimbabwe and the Voluntary Media Council of Zimbabwe, were representing us at the Nyanga meeting, where Chris is going to, update us with our legal counsel with the Media Alliance of Zimbabwe. So I'm going to hand over to Chris to handle the update because it's of a legal nature. You know, when you are engaging, it's not an easy process. It's a collective process. So you need legal counsel, you need some that can talk, you need some that can just cheer. You also need those that criticize, isn't it? To say, kunana mazu, komisa, what, amuna zvamurikuita. Saka tatirege tibo itabasa. Thank you very much, Chris.
Thank you. Many of you recall that I'm also very much a member of the media profession, having cut my teeth as a journalist, and I continue therefore to be passionate about media reform. And we congregate today specifically because we're at a critical stage in the law reform process in respect of the media. It is important that the media takes a central role in making sure that the process unfolds with the results that we expect, being primarily better media laws and better policies and a better working environment for journalists, and also deeper spaces for citizens to freely express themselves. And therefore you will recall that the media reform process has been running for quite a while now. It goes back even to the days of IMPI, the inquiry into the media space by the government of Zimbabwe, and very critical recommendations were submitted by that committee. And closer to now, we recall the call by the president to make Zimbabwe more democratic, and he included in his legislative agenda the media law and policy reform agenda. It's important, therefore, that we take stock from time to time of the progress that has been made, and to call upon the media to do more in making sure that the general citizenry is well abreast of recent developments and that they participate in the ongoing processes. We are, as an alliance, pleased that government has been more open in involving civil society and other members of society outside government. We had a number of consultative interactions in 2018. The Ministry of Information, Publicity and Broadcasting Services invited MAZ and its partners back in November 2018 to make submissions, and we have placed before government very specific positions and policies that we wish to see in the new laws. MAZ also conducted its own media stakeholders conference in November 2018, and government commendably participated in that consultation. There have been a number of other consultative processes, including the workshop in Nyanga 3 weeks back, where MAZ was also invited to participate in the bill-making process. These have been positive developments, but we are here today to say it is not good enough. We expect, as Media Alliance of Zimbabwe, to see more being done and to see the refinement of the consultative process. We know that in the next few months or so, bills will be presented at Parliament, and members of the public will also be called upon to participate in those processes. We are not sure at this stage whether or not the positions that we have presented to government have been infused into the current bills that government is working on. There are no signals as yet to show that government has been listening to the input of civil society. We will know in the next few weeks, once we see the first bill being presented at Parliament, whether or not that consultative process has been sincere. So as we do that, we want to restate the fundamental positions of MAZ as we go into the next stages of the reform process. The key highlight in the law-making process that we should take note of is the fact that Parliament is compelled to consult with members of the public. There will be a public consultation process once the bills are before Parliament. And we urge Parliament, therefore, to make sure that that consultative process with the public will be genuine and sincere, and that the final product will reflect the specific submissions by the public. Ordinary members of the public who are not necessarily active in journalism or mass media have a fundamental interest in the quality of the laws that will come out of the ongoing reform process, because media freedom is very deeply linked to freedom of expression. And freedom of expression is not only for journalists but ordinary members of the public. So we are together with all other members of society in calling for media laws that will enable journalists to work freely and members of the public to express themselves freely in their day-to-day lives, and also in critical national processes such as lawmaking and determination of usage of resources and taking government to account, and all of those processes. Those are critical. So having gone through those consultative processes, we wish to restate that the forthcoming laws that will be presented in Parliament must decriminalize journalism. We have seen in recent weeks and months that although government has been pontificating about doing things in a different way and making sure that the democratic space is broadened, there are still too many incidents of harassment of journalists and violation of media freedom rights. The current law in respect of the media does not have sufficient safeguards in making sure that journalism is decriminalized. We wish to see in the new laws that are coming a complete decriminalization of the profession. We also are unhappy about the state of broadcasting in this country. That we have one TV station nationally is completely unsatisfactory, and there's no justification whatsoever that 39 years after independence, we still have just one TV station. This is the result of the lack of implementation of the existing laws, which provide for a three-tier broadcasting system, being commercial, community, and public broadcasting. The licensing system, as it stands today, has not been sufficiently fair and progressive to ensure that the three-tier broadcasting system is accomplished. The new laws that are coming on stream should therefore be more effective in making sure that broadcasting is as diverse as it should be, that the airwaves should be opened. Another critical principle that we wish to point out that we've already submitted to government is the issue of convergence in terms of regulation of the media. There's over-regulation of the media, and one of the reasons for that is the fragmentation of the regulatory system. It is important that we see regulatory convergence coming on stream so that the profession of journalism is not overstretched. And still on regulation, we have made it clear to government that the media deserves to self-regulate. Self-regulation is a critical component of all democratic states, and we wish to see the new laws taking sufficient recognition of the importance of self-regulation in our media sector. And my colleague Lofty will speak a bit more about the self-regulatory aspects of our calls.
And actually, forgotten to introduce ourselves. We're thinking the names. I was thinking the names were circulated, but this is Nigel Nyamtumbu, Chris Mike, Lofty Dube. We also have Puda Owe, our legal and ICT officer at the Media Institute of Southern Africa. Yeah, thanks. So, Lofty, you can take it.
That's fine. Okay. Lofty will come in at the end. You will recall that the Constitution of Zimbabwe does in fact permit Chapter 12 institutions that are constitutional commissions to delegate some of their duties and roles. It is the position of MAZ that it is well within the law for the Zimbabwe Media Commission or other media regulatory bodies that will come on stream post the reform process to delegate some of their regulatory processes to other institutions. And in this particular case, we are referring to the existing self-regulatory mechanisms. We do have a Voluntary Media Council of Zimbabwe, which has come up with a code of ethics for the practice of journalism, and that system has been working fairly efficiently over the years. So a core regulatory system would ensure that while government has a role in making sure that there's good practice of journalism and that rights are protected, the profession itself will also have a critical role in upholding and maintaining and advancing the standards of the profession. So this is a critical point that we wish to see well captured in the new laws that are coming on board. We want the media freedom and freedom of expression platform to be broadened. So we are calling for the abolition of the censorship board. This is an archaic institution that has no place in a modern democracy. The relevant law that establishes that kind of body should therefore be repealed or substantially amended. It is also important to point out that the new laws that we see coming on stream must have clearly defined safety and security considerations for women media workers. We have seen too many incidents of harassment and violation of rights in respect of women media workers. The newsroom should be a safe place for all women journalists and media workers. The current laws do not sufficiently provide for their protection. We wish therefore to see the new laws being firmer in protecting our sisters. The accompanying policies and regulations should also speak to the issue of their safety. We also are seriously concerned with the the safety of children and youths in their interface with the media. The media landscape has been changing significantly due to technological changes. Our laws do not respond to the various risks and dangers that children and youths face offline and online, but particularly online in their online activities. So we wish to see laws that will enhance the opportunity for children and youths to enjoy freedom of expression and access to information, but which will also protect them from the various risks and dangers that we see in the modern communication process. So all other laws that impinge on media freedom should also go or be significantly amended. The ongoing process that I and other colleagues participated in focus mainly on IPA and Broadcasting Services Act. Those are the main statutes that are being reviewed, but also the cyber laws. There is no mention of other statutes like the Official Secrets Act, the Censorship and Entertainment Controls Act, the Criminal Law Codification and Reform Act, and the Interception of Communications Act. Talking of the Interception of Communications Act, you will recall that fairly recently we were all affected as media practitioners by the total shutdown of the internet. That came through the existence of this particular statute, Interception of Communications Act. Though it was very badly implemented by government, the fact remains this toxic piece of law continues to be on our statute books, and it infringes on the rights of journalists and citizens generally to freely express themselves. Many journalists have been arrested under the Criminal Code, the Criminal Law Codification and Reform Act. These laws have not been part of the alignment process that we have been involved in, particularly because the Ministry of Information is not seized with these particular statutes. So it is our position today that all other laws besides IPA and broadcasting laws and the cyber laws should also be urgently reviewed so that the democratic culture that President Mnangagwa has been talking about is truly opened. The government of Zimbabwe has been saying Zimbabwe is open for business. We submit that that openness should also extend to the media spectrum. Investment laws relating to the media tend to limit the ability of investors to also invest in the media. So the new broadcasting laws that will come on stream must not in any way be restrictive of investments, domestic or foreign. Opening up investments in all sectors of the media will ensure that the media does progress and develop, and it will also ensure that we tap into the skills, wealth that does not necessarily reside in Zimbabwe. Ladies and gentlemen, these are the points that we thought we would share with you. The media law and policy reform agenda remains urgent, and we call on government to treat this agenda with the urgency that it deserves. Thank you.
Thank you very much, Lofty.
Thank you. I would want to add on to a couple of issues that Chris has spoken to. These are MAZ positions, and these positions, we've had these positions over a long period of time since IPA was enacted in around 2002, or even before that. We have had these concerns as the media. What do we envisage in the new laws that will come in? We're envisaging a situation where we have laws that are not reflective of what issues we have been complaining about as the media. Chris spoke about the issue of decriminalization of the profession. IPA criminalizes the profession. We will be very disappointed. There will be no difference to a law that will come in place that would still criminalize the profession. I think under IPA, a journalist was liable to, is it a fine of level what?
A fine and
a possible jail term of 2 years, is it? If you go to other laws, I think, is it the Official Secrets Act, which stipulates up to 20 years imprisonment for practicing the profession. So it's one of the issues that we feel whatever law should come in place that guides the operations of the media, it should decriminalize the profession. As long as we have a law that still criminalizes the profession, it's not different from IPA. We will not say we have a reformed law that still talks about the jailing of journalists for doing their job. So it's an issue we're very critical about. And in the discussions in Yanga, myself and Chris were part of the inter-ministerial task force and the AG's office that was going through the bills that they proposed to table before Parliament. We're hopeful that any law that comes out should decriminalize the profession of journalism. That is sacrosanct. We are not negotiating on that, and it's a position that the media has had, and it's a position of the Media Alliance of Zimbabwe. Chris spoke about the point of reform. I think there are about 18 laws that affect the journalists that we have complained about. He spoke about the Interception of Communication Act, the Official Secrets Act, the Criminal Codification Law, I think the Parliamentary Privileges Act, the Protected Places Act. These are some of the laws that infringe on media freedoms and the operation of journalists. So it's a starting point is good with the amendment of the 2 laws that Chris has alluded to, the issue of IPA and the Broadcasting Services Act. But these are only 2 laws out of a plethora of laws that affect the operations of the media. We would want a wholesale process that includes a relook into all these laws that infringe on media freedoms and on Section 62, 61, 62 of the Constitution, which talks about media freedoms, the freedoms that the media should enjoy, where they have access to a lot of issues that are prescribed in the Constitution. So, as we look at these 2, we're mindful that they should also be a precursor and reflect in the future of reforms that are targeted at the law. Chris also spoke about the 3-tier broadcasting system, where we have a public broadcaster, what is that on commercial, and community broadcasting. Zimbabwe is one of the few countries that does not have a single community radio station. So we are hoping that a law that will come in place. He spoke about the lack of implementation of the law. If you go to the Broadcasting Services Act, it gives provisions for the establishment of a community, even though government has been trying to define what a community is. We have an idea what a community is, but it's an issue of having timelines that would ensure that independent community radios are established. The issue of regulation, we have spoken on the issue of self-regulation as being the best. We're looking at issues of best practice and what is applicable elsewhere in the world. Our argument is grounded on the fact that self-regulation has worked in Zimbabwe. We've been in business since 2009, and we've been doing work relating to media conduct and handling of media complaints. We have reports to prove that. But our work is also grounded on the laws and charters and international statutes that Zimbabwe is a signatory to. The Banjul Declaration speaks of self-regulation as being the best mode of regulation. The Windhoek Declaration of 1991 speaks to that. The IMPI report that Chris alluded to, in its recommendations, says they firmly believe self-regulation is the best form of regulation in the long term. But they then argue that the way Zimbabwe was politically and through other processes, they felt the best was co-regulation, which we firmly believe, under the circumstances where we have a constitutional body like ZMC, it will be one way to go. And we're hopeful that an outcome in terms of the bills that will come out of this long process, which is ongoing, which we firmly believe has to be long, so that it becomes consultative and all-inclusive, should have a self-regulation contained in the statutes. It's a way of raising standards in journalism and increasing professionalism in the media. These are some of the issues we felt are quite critical, and we feel the media has a role to propagate these issues and cover them widely and adequately for the benefit of society.
And on co-regulation, in fact, Cabinet has approved the principle of co-regulation. And therefore, any law that does not fulfill that principle that has already been approved would be contrary to government's own undertaking. It's also important to make it clear that we do not have to wait for the completion of the media law and policy reform process to see an improvement in the operating environment. We had at least 6 incidents of violations between October and December 2018, and up to 18 violations between January to present. Perhaps Kuda, whoever of MISA can speak a bit more to that issue. This is completely unjustified, even in the context where laws have not yet been fully aligned with the Constitution.
Okay, so this speaks to the issue of the safety of journalists when we are talking about media law reform in Zimbabwe. The current regime of laws in Zimbabwe actually promotes state-sponsored violence against journalists, and the cases that he highlights are actually cases in which the state had a leading role in actually violating media freedoms. So we see people or journalists getting involved in issues, maybe when police are arresting offenders, and then during that sweep, they also take in journalists. We also see issues where members of the military, when they had operations mainly in August and January, they also carried out media violations against journalists. And we also see situations where party supporters from both the ruling party and opposition parties are actually violating media freedoms as well. And some of the serious incidents actually involved the physical harm of journalists. So, for example, there was one in October or November, which involved Philemon Jambaya, where he was actually beaten up and then detained, and it took the intervention of MISA and legal teams from other organizations like Chris to actually get those people legal assistance. And then another example of how a law was used to violate expressive freedom, the freedom of expression in Zimbabwe, was the recent arrest of the Pastor TV crew, in which they were arrested for a 2016 skit. So if it was a genuine
some Chinese phone.
Some Chinese phone is making.
so
it's off.
So it was a skit that was done on short in 2016. It was circulated in 2016, and it has been in the public domain for the past 3 years. But then we see the police then rely on the criminal law code to arrest these people in 2019. So if it really was an offense that was based on the production of the skit, one would have thought that they would have been arrested when the skit was released. But then the time lapse would indicate that maybe there were other issues that had then come up, maybe recently, maybe under the current government's priority areas, that then made it necessary to make an example by arresting people from Pastor TV. So that's again the other nature of the new nature that we're seeing against media freedom violations. It's no longer against journalists, but it's also against anyone who is in the creative arts. So content creators who are now using or relying on free expression to maybe comment on social events in Zimbabwe or current affairs in Zimbabwe are also now in the line of fire. And this is all promoted or enhanced by the existence of the laws that were mentioned beforehand, laws like the criminal law code, laws that criminalize criticism against the government or government authorities, or laws that criminalize fair comment against the office of the president. So AIPA, or the reform and repeal of AIPA, is just the beginning. And as members of the media, I think we also have a role to play in actually discussing these issues. So let's, in our stories, let's start to write about what is wrong with AIPA, how AIPA doesn't only affect the media, but it also affects day-to-day life in Zimbabwe. Because if you now then send maybe a WhatsApp message that is seen not in a favorable way to government, as a private citizen, you can be hauled before the courts, you can be put into detention as well. So this matter is now beyond just affecting media practitioners in Zimbabwe, but Zimbabweans in general. So we really need to sort of start writing in a way that encourages people to be curious and people to take the time to actually educate themselves around free expression issues, access to information issues. And I think that's all I have.
Right, thanks. Tisatatora mubvunzo. Ngopeta nemashoko vanga vachiwanza chirungu. Tombotaurawo pamwe nevari kuona vanhu vangadeshona isiri kungoda kusunungutswa kwezvekufambiswa kwemashoko nai kuti tingawanze kufungirana kana tisingapanane information. Saka access information itori kodzero iri mubumbiro remutemo. It's a constitutionally guaranteed right. Protection of sources, for example, it's also a constitutionally guaranteed right. Basa revatori venhau harina kuipa, harisi rekutsvaga mhandu aiwa. Basa revatori venhau nderekungopa kuti vanhu vazive zviri kungoitika mudunhu ravo, vanhu vasafungirana asi vari kuita sei vangoziva information. It's just for the benefit of citizens. Let's take question.